In a criminal case, once a jury begins its deliberations, what do the attorneys do? Do they just sit around and do nothing? Well, actually, they do quite a bit. Let's talk about it. Hello again, everybody. My name's Sean Martin, attorney at law. I'm an attorney in the Cleveland, Ohio area with a law practice that focuses primarily on criminal defense work. Today, we're going to talk about what happens once the jury takes over. At this point, we've already gone through jury selection, opening arguments from both the prosecution and the defense team, the prosecution's case in chief. The defense, if they presented a case, has gone. Then there were closing arguments. The prosecution went, the defense went, and then the prosecution had the rebuttal arguments. The judge has given jury instructions, and the jury has begun deliberations. So, what do you do now? At this point, there are quite a few things you're going to start doing as an attorney, whether you work for the prosecution or defense counsel, in preparation for the jury reaching their verdict. One of the things the attorneys involved in a criminal case may begin to do is anticipate possible juror questions. Usually, a jury may have a question about questions of law, how to interpret law. They may even bring up questions about facts in a case, or it might make a request. You don't know what it's going to be specifically. You may have hints about what's going to happen. For example, while both attorneys are working on submitting jury instructions to the court, if there's disagreement over a specific issue or a ruling in law, then you assume the jury might have that problem as well. Or if there's a contentious issue during the case, you need to be prepared the jury might be focusing in on that as well. So right now you'll be looking and doing research, preparing to handle that issue should it arise. The second thing you may do, and this is very dependent upon your state's criminal procedure work, is motion practice. Some states may require motions and other things to be filed as the jury begins deliberations. That's very dependent on your state, but it certainly could happen. You'll be preparing those motions, researching those motions, and getting ready to argue them if necessary. The third thing is a fairly obvious one, at least for one side of this equation: client management. Now, for the defense counsel, he's going to have to manage the defendant, his client. Keep them calm, keep them informed. If your client comes to you with questions, certainly you're going to ask them. Do everything you can just to make sure that they're hanging tight and being ready to wait. There's not sometimes so much you can do except tell them, just sit tight. But they may ask you questions about what's going on, and you have to do your best to fill them in. Now, on the prosecution side, they also do have some form of client management. Generally, it's through the victim of the case or the victim's relatives or representatives. And also, in some cases, they may have to work with the law enforcement officers involved, such as the investigating officer, or in fact, the officer himself might be a victim. Keeping them in contact, letting them know what's going on, keeping them apprised, especially with the advent of victims' bills of rights, such as Marcy's Law, gives a lot of involvement there. Now, typically, the fourth thing is more about looking towards the future. What are you doing about the rest of your schedule? Do you have a trial right after this one? What's the rest of your schedule look like tomorrow? Do you have hearings? Do you have interviews with clients? Do you have interviews with other parties? Are you conducting work? Do you have the day off? What's going to happen? Now, for a prosecutor, are you interviewing witnesses? Are you interviewing law enforcement? Do you have a suppression motion to prepare for? Do you have an appeal to prepare for? For the defense counsel, what are you doing tomorrow? You might be signing wills tomorrow. You might be doing a personal injury case tomorrow. You might be doing any number of things tomorrow, just as likely as the prosecution. This is not your only case. You've certainly got far more going on. You have to prepare to deal with the rest of your life. You had to put on hold to take care of this trial. Especially in a longer trial, the longer it takes, the more you have to focus on what you're going to do to get back up and running. Because remember, when you're in trial, you can't have other hearings. You can't deal with other clients. Your sole focus is the trial itself. So that's a big problem in regards to soaking up all of your available time. And then finally, the fifth thing you're going to do, and probably the most obvious thing of all, even while you're working and doing all these other things, is waiting. You're going to wait some more, and wait. Now, you might be in a situation where the jury comes back right away. Maybe 20 minutes. Might be 20 hours. Might be 2 days. Might be a week. You don't know. So what do you do in the meantime? You just get back to work. But even then, it's still in the back of your mind. You're working, but you're also thinking about the case. You're thinking, are they going to come in? Well, that's it for today, and I hope this has given you some information. It's some insight to what attorneys do. They do far more than just sit around and wait for the verdict, wait for that phone call from the bailiff saying, the jury's ready for you. If you like this content, please click the like button, comment or question below. Remember, there's no such thing as a dumb question. And remember, until next time, just because you did it doesn't mean you're guilty.